What do I do? Therefore, I think, let me try this. And the court will come and say, no, I'm sorry, your trial is bad. I don't think a trial and error can be done like that. I think every day's national economy is a matter of trial and error. Racial criteria or normative criteria. So you could have chosen 10 series, you could have chosen 5 series. Look at what happened thereafter. I don't think the court will ever get into it. There can be bankers' disagreement on that, experts will disagree. That if the government wants to come.
The word any is used twice.
That's how it is tested. I understand.
There is a choice or an option, only this particular denomination. But if you say any means all series of all denominations, all notes.
Why?
A word used any is twice. Any series, any denomination.
Why is it? I'm asking a question. Why is it used? So therefore, in both places, either any should receive a common meaning for both the expression, or it may have different meanings also, depending on the context.
No, if
the exercise of power in a given case.
If your argument is to be tested as any means all, that means you can demonetize all series of all denominations on one day.
That if the government wants to come.
The word any is used twice.
That's how it is tested. I understand.
There is a choice or an option, only this particular denomination. But if you say any means all series of all denominations, all notes.
Why? The context is very important. Any one of the denominations with the government and the RBI will choose to decide for any one of them.
Yes.
That's right. That's how it must be read. I'm not saying any means all.
That is how you want to.
That's right. That's how it should be read. Therefore, once that any one of them, a few of them, such of them, you can give that very flexible meaning. Once they decided, then what kind of series will necessarily be again connected to the decision on the denominations issue. You can have one series, you can have all series, you can have few series. Therefore, don't try to narrow down the meaning that can be given to a very important dynamic part of section 26.2. It must say, unless there is, suppose it's very difficult even to say the government would not apply its mind, RBI would not apply its mind to what kind of denomination, what kind of series. They're all within the knowledge and domain of both parties. So to enter into a discussion on some kind of external racial criteria or normative criteria, so you could have chosen 10 series, you could have chosen 5 series. Look at what happened thereafter. I don't think the court will ever get into it. There can be bankers' disagreement on that, experts will disagree. Finance ministers may disagree.
Yes.
But I don't think the court will
ultimately, the choice is yours.
Yes.
This is what you want to suggest.
That's the choice is mine. Depending upon the compulsions, the perseveration, the compulsion, the perseveration, and the felt need of the government and the RBI in doing what am I going to do, what I want to do.
Yes.
So will that area of perseverance and compulsions, which will be connected by a series of dots. The dots are within the knowledge of RBI and the government. Now the petitions want to say,
no, whether it is good or bad is a different aspect.
Yeah.
But you have the power under section 26.2. This is what you are suggesting.
That's right. That choice. How do you what the
choice is yours?
Choice, yes. Provided somebody will ask, then how do you have a choice? What is the criteria for a choice? My twofold submission on that. The choice will be certainly persuaded, will be by certain factors which come into the understanding of the government and the RBI. I mean, not called upon now to deal with a very major issue of reformation of a monetary policy. Black money sitting like this, fake currency, always a teasing illusion. What do I do? Therefore, I think, let me try this. And the court will come and say, no, I'm sorry, your trial is bad. I don't think a trial and error can be done like that. I think every day's national economy is a matter of trial and error. And Blood Fund knows about it. So therefore, I'm saying 26.2 must receive a dynamic interpretation. Let me proceed further.
But you can't say my learned friend knows it. We may have to cite him as a witness. All right, tell us.
What?
Yes.
In section 34, which Mr. Shyamdev read out, Lord, so kindly come to section 34. Then I'll straight away go to the ordinance and the act. The liabilities of the issue department shall be an amount equal to the total of the amount of the currency notes of the government of India and the bank notes for the time being in circulation. Therefore, the liabilities of the bank Where are they? In this? Into the court. We'll also have this compilation of this relevant notifications, ordinances. 46 and 78 Act. Very small.
We have, but then we have already parked in that comparison, so it will be more convenient to.
48, 78. 46 and 78 is not.
Anyway,
Yes.
This is all post 1970. Yeah. This is the reason which makes it necessary to provide for the demonetization of certain high denomination banknotes. Exercise in powers conferred by Section 72 of the Government of India. So and so. The Governor General is pleased to make and promulgate the following ordinance. You can skip those definition provisions. Kindly come to Section 3. On the expiry of the 12th of January 1946, all high denomination banknotes shall, notwithstanding anything contained in Section 26 of the Reserve Bank of India Act, cease to be legal tender in payment or on account of any place in British India. Then prohibition of transfer, then exchange in 4, 5, all those provisions, 4, 5, 6, etc. I don't propose to deal them. There are dates fixed here, and then we have the 1978 Act, which is at page 18.
Yes.
In the 1946 Act, they talk about an emergency. Now they're talking about page 19, the preamble, an act to provide in the public interest for the demonetization of certain high denomination bank notes for matters connected to and so, whereas the availability of high denomination bank notes facilitates the illicit transfer of money for financing transaction. Look at the shift in the focus of the understanding. So illicit transfer of money for financing transactions which are harmful to the national economy or which are for illegal purpose, therefore necessary in public interest to demonetize high denomination banknotes. Now look at Section 3. On the expiry of the 16th day of so-and-so, all high denomination banknotes shall, notwithstanding anything contained in Section 26, cease to be legal tender, parliamentary provision. We're talking only about Section 26. Now, as far as other provisions are concerned, they are more or less the same. Now, kindly come to page 3, the ordinance in question.
Ordinance in the present case.
Your Lordship, 8th of November 2016.
But Mr. Attorney General, one of their contention is you had made two acts. One is prior to 1940, what is that act?
46 Act,
46 Act.
1978.
Ordinance, all right, ordinance or act, what? And this time again act in 78. But why now under 26(2) notification? This is one of their question actually.
I'll answer that question. I'll definitely answer that question.
Yes.
Now that will be again a matter the court is asking me or somebody.
You can answer later, but please keep this in.
Exactly, I'll answer that question.
Yes.
I tried to apply my mind to it.
Yes, yes.
Come back to it. Now, these are very important questions to be answered.
Yes.
The notification reads like this. I only want to say the shift, the focus is, and how the canvas has become little wider. Emergency 46, then public interest 1978. Now the enlargement of public interest. And the compulsions and the persuasions.
The compulsion is one. What they said was, because the government knew that that power is not there, these are enacted. Therefore, how suddenly the power comes into the act now for just issuing a notification is their
The
contention.
power is always there.
No, there should have been, like that
My-
was there, why earlier it was issued is.
My submission, the power is always, the power is always.
No, no, if the power is already there in 26(2), so it is an occupied field. If that is so, how can there be, because this act is of which year? This 1934 Act.
34.
In 1948, you bring an act. So was it without jurisdiction, that act?
No, no,
Or 78 Act? Because
I-
if you say it is an occupied field under 26(2),
A statutory occupation
huh,
does not negate
huh.
parliamentary plenary powers.
No,
A
the
statutory occupation stands on different footing.
statute is also by
Parliamentary plenary-
parliament only.
Parliament is, no, that is a statutory provision.
Huh.
Under section 26, government will act, RBI will act. But the parliament says, look here, notwithstanding whatever can be taken in 26, I want to enact a law. Therefore, the plenary powers of parliament are always available to the parliament. They are never impeded by a statute on hand. Therefore, whatever persuasion which parliament then thought, why should I not go? Why government could have said, I'll go under 26. But parliament said, I want to do emergency. Therefore, we are looking at now from a retrospective point of view.
See, 26(2) itself says by notification in the Gazette of India. Therefore, you can do it by notification, I suppose.
No, parliamentary,
It is permissible.
parliamentary legislation is also gazetted. That's a.
Contention
I'm
that
only.
must be by an act.
No, that's a small issue.
Need
I'm-
to be.